Discovery means providing information or receiving information to or from the other party. Documents. Oregon law requires that parties in a separation, divorce, or dissolution of a registered domestic partnership case provide each other with documents about their assets, liabilities, income, and expenses. This has to be done within 30 days if a party has served a form or serves a request for production of documents. This is an affirmative obligation which cannot be shirked by claiming the documents are with a third party or just too hard to find. From the moment you're getting ready to file or you know of the pending action, you should gather documents and information. If you usually discard bills, stop that practice immediately and keep and organize your bills from this point forward. Go online to get past credit card statements. These are kept for a limited number of months, so do this immediately to capture the oldest information available. Get copies of records dropped off with a tax preparer or accountant. B. Requests for production. If you've not received the documents you need to prepare, don't wait around. Send a request for production, identifying the documents and allowing a reasonable time, usually 30 days, for their production. If you have received a request for production, respond to it by preparing a document which goes number by number, responding to the request, such as number 11, trusts, right? None, if you don't have any. You must provide your original response to the other person's lawyer or the other party if he or she doesn't have a lawyer. Requests and responses for production of documents are not filed with a court, but be sure to keep copies for yourself. See motions to compel production and orders compelling production. If your request for production has not been reasonably responded to, don't wait around. File a show cause order to compel production. Ask to get it on the docket right away. Mailing it to the court takes extra time which you may not have, so take the document to ex parte time if at all possible. If you show up at trial unprepared and you haven't gotten an order compelling production, you may be out of luck. D. Depositions. A party may take the deposition of the other party or a third party who has information relevant to the party's case. A deposition is a sworn statement in which questions are asked of a party or a witness. The statement may be recorded by a court reporter who charges fees for attending and preparing a transcript. The statement may also be recorded by electronic means with proper notice to the other party. If you wish the other party to bring documents with them, you must give them notice of that as well. In a deposition, the party asking questions may inquire in areas beyond the rules of trial evidence if the information might lead to relevant information and the questions are not designed to harass or embarrass the deponent. If the deposition is a non-party, the witness must be subpoenaed. While the subpoena form is free and available at the clerk's office, it must be served accompanied by a payment to the witness with the proper witness and mileage fees. Cross-examination in depositions is allowed. All parties must be notified of the date, time, and place of the deposition. The law library may allow you to reserve a quiet and comfortable space for the deposition if you need a neutral location. E. Records deposition. If an accountant or a school, hospital, or an agency has records which you're unable to obtain, you can set up a records deposition which identifies a date, time, and place for production of them. The holder of the records must be subpoenaed with the proper fee and the other side notified of the records deposition. The deposition can be satisfied by the third party forwarding the documents to the subpoenaing party. The receiving party has an obligation to photocopy and send a copy of the documents to the other party. DHS and CARES Northwest records. Now, you're not likely to get a copy of records from DHS or from CARES Northwest. You can have them sent to the assigned judge for an in-camera review, where the judge looks at it, decides what you get to see. You won't end up with copies, but at least you'll get a summarization of the information. You can do this by doing a records deposition and having the records sent to your assigned judge. G. Requests for admission. Well, these are rarely used in family law cases. One party serves the other with a request for admissions, which has sufficient space and lines for the other party to write in the admission, denial, or explanation. And failure to admit or deny within the time allowed may result in the admission of the requested statement. If you are served with a notice of deposition, it's important to attend the deposition, or the judge may order you to pay the other party's attorney's fees and the court reporter fees associated with the deposition.